the victim's rights are not absolute and must sort of take into account what is occurring on the ground in the circumstance. And I think in the circumstance where the state and the circuit court have agreed that a defendant has been wrongfully incarcerated for 23 and a half years, it is appropriate that the court move with urgency. And given that.
But doesn't that then get into elevating, again, that sort of concept of defendant's rights over victim's rights? I mean, doesn't, if practicable, I understand the context argument because that was what was argued certainly during the 80s about this. But does that mean that the context of a hearing, if you're going to set in a hearing, should the judge have considered any of the victim, the context of the victim here in setting the hearing date? I understand the urgency, but I'm going to the if practicable in that context.
Well, Your Honor, in setting the hearing, I certainly think that is a factor which the court could take into consideration. But I think that in terms of what the state was required to do, the state here complied with its obligations. And I think as Judge Berger noted in his decision below, in his dissent below, the sufficiency of notice can't be assessed in a vacuum. It's got to be assessed in the context of what it was intended to do. So if we look at what the victim, the right that he had to do, the right that he had in this case, which was notice and attendance, he was notified, he was able to attend. Judge Berger observed that his attendance by Zoom was sufficient, and perhaps there would be different questions if the court found that he had a right to participate. But given the limited nature of his rights, that under these circumstances, his rights were satisfied.
Thank you.
I have another question about practical, because that word also appears in Article 47B of the Declaration of Rights, which says that if that victim upon request and if practicable has a right to be notified of, to attend, and to be heard at a criminal justice proceeding such as the one that went forward here. Article 47 was, of course, enacted before the vacatur statute was enacted. Could the General Assembly, in light of, would you agree with me that it's obviously practicable to allow a victim or victim's representative to be heard at a vacatur hearing? It's practicable. It happened here. It's possible, right?
Yes, Your Honor.
So would the General Assembly be permitted under Article 47 and under the Constitution to deprive the victim of the right to be heard in a vacatur proceeding, given that it is practicable?
Well, Your Honor, I think that the other caveat in Article 47 is as these rights are implemented. And so the General Assembly saw fit to implement these rights in a specific way. And whereas in sentencing or a modification of sentence, where the court is required to take into consideration victim impact in fashioning an appropriate sentence or reduction of sentence or no reduction of sentence, that is an appropriate time for victim impact. But with regard to the sort of analysis that happens in a vacatur or, again, in a petition for writ of actual innocence or a post-conviction, that the victim's impact doesn't weigh into the court's analysis in the same way.
Let me ask you this, hypothetically, with regard to because it seems as if what Article 47 did was, as implemented, made in a matter of constitutional law those rights that for victims that existed at the time the article was enacted. So in other words, one way to think of it is a floor. Could the General Assembly, with regard to some other right, maybe 11403, some right that already was in existence at the time of the enactment of Article 47, without a showing of a lack of practicability, could they repeal a victim's right that was made part of, that was kind of recognized as already implemented in Article 47 at the time? It became a constitutional matter.
Not without a constitutional amendment, I think, Your Honor.
So qualitatively, if we have a right that we think is very similar to rights that were enshrined in the Constitution for victims, let's say we believe that the right to be heard, if the being heard at a vacatur hearing is qualitatively very similar to a right that could not be repealed, like in 1143, should we infer that the General Assembly believed that there was a right to be heard? If you look at what Delegate Barron said, it seems like a lot of the legislators thought that, of course, victims would be able to be heard at vacatur hearings. Should we infer that there is such a right?
I don't think that's necessary, Your Honor, because I think that the language is clear and therefore we don't need to go beyond the plain language.
But under the, I'm sorry to interrupt your train of thought, but under the plain, if you're referring to the plain language of Article 47, doesn't the plain language say that the victim has a right to be heard?
Your Honor, again, I think it's as the rights are implemented. And I also think that with regard to Article 47, there's also the caveat in there that the victim's lawyers may, or rather the victim does not have the right to seek a stay in a criminal proceeding. And I think that that caveat recognizes that there are circumstances in which a victim's rights may be, mooted by other circumstances. So for example, in the bail context, a victim has the right to be notified and to attend a bail hearing, and there may be circumstances under which that does not occur. Now, a victim has the right to note appeal and appeal from that, but they also don't have the right to seek a stay in a criminal proceeding. And so if that trial continues and there's an outcome, that may very well, if it's resolved before the appeal, moot out the victim's rights. And I think that that is sort of baked into our system. So this is not the only circumstance under which a victim's rights may be mooted. And in this instance, the state was operating both under an obligation under Rule 433 and the court's order in this instance that they move to null pros these charges within 30 days.
Well, 4333 says they have to do something within 30 days. They have to null pros the charges or take other appropriate action.
Yes, Your Honor.
Another appropriate action could have been for the state's attorney to join in a motion to stay so that an appeal would not potentially be mooted, right?
That certainly could be an action, but there's nothing under the law which requires the court to do that. And I suppose there might be a conflict if the state did join in an action to stay, given their obligation under the rule itself. The state in this action lawfully moved to null pros, and there's no case, Your Honor.
Go ahead. No.
The one case that curtails the state's power, Hook, to grant a null pros is inapplicable in this case.
Well, understanding the circumstances of Hook are obviously different than those in this case. Why should the concept of the state not using a null pros to interfere with fundamental fairness, why shouldn't that apply to victims' rights?
Your Honor, in 1991, the null pros rule was approved by this court. Previously, the state in entering a null pros had to put their reasons on the record. But this court in 1991, at the request of the then deputy state's attorney, removed that requirement so that the state could null pros for any reason, and sort of in contrast to the federal system, which requires leave of the court to enter a null pros. That is not the case in Maryland.
And so the question is, why shouldn't the basic principle of the state using a null pros in a way that is fundamentally fair apply to the victim's rights?
Your Honor, I think the question of whether or not, in my view, there has been no finding as to the purpose of the state's vacatur. And I think sort of like the bail context or in other contexts where action in the circuit court, where it still has fundamental jurisdiction, moots the appellate right, that is a function of our system. But Your Honor, to the extent that it is not fair, or to the extent that it is appropriate to change that, that is, in my view, something that ought to be taken up with the General Assembly and the Rules Committee. Your Honor, I see that I'm in my rebuttal time. Well, does the court have any further questions?
I don't see any, and thank you. Thank you.
Thank you, Your Honor.
Mr. Rubin.
May it please the court. My name is R.E.B. Rubin, attorney for Sanford, Heisler, Sharp, here with the chairman of the firm, David Sanford, and we are pro bono counsel to the cross petitioner, respondent, and murder victims representative in this case, Young Lee. Your Honors, this case is not about Mr. Syed's underlying innocence or guilt. That dispute is simply not in the room today. What is are issues of open courts and Mr. Lee's rights at a vacatur hearing. We will ask this court to uphold the appellate court ruling in all regards, other than with respect to the holding on the ability to speak to the evidence. Specifically, Mr. Lee will ask this court to remand the case for a new vacatur proceeding, one that is legally compliant in providing reasonable notice, the right to attend in person, and the right to be heard on and challenge the evidence. The vacatur statute, Criminal Procedure 8-301.1, which brings us here today, is an extraordinary piece of law in that it aligns the interests of the defendant and the state. The state, in fact, must move on the defendant's behalf. And in so doing, it eliminates one of the very bedrocks of our judicial process, which is the adversarial system. Without an adversary, there can be no meaningful check on the evidence, and the circuit court is impaired in the fact-finding that it must do. As such, read in the penumbra of the constitutional protections that are provided to victims as well as the statutes, it was clear, either in the drafting of the vacatur statute to the legislature or clearly within the vacatur statute, that for lack of a better term, the right to be heard on the evidence was baked in.
Mr. Rubin, why isn't this a question for the General Assembly? It's the right that you're speaking of is not in the plain language of the statute.
So we believe it is in the plain language of the statute, Your Honor, and we believe that the right to be heard on the evidence exists in no less than three specific regards within Maryland. Number one is in the Constitution under Article 47 of the Declaration of Rights. It provides a freestanding right within Subpart B, caveated only by the term as implemented. As implemented, just by its plain text. We don't read it to mean that it must be enacted for each individual law. As implemented means to carry out, to give practical effect. It is a right that the legislature can shape and restrict where necessary, but where silent, constitutional rights are to be expanded and read into the law, not disregarded. So that's.
So would you say that if there's no right to speak at a post-conviction proceeding, is that statute inconsistent with Article 47?
Well, we would, at the post-conviction proceeding, we would read that statute as silent. I will note with the uniform UPPA, there is also a cross-reference to 11403 in the implementing rule of that statute. But again, we believe that this statute is unique in the significant respect, and for that reason, we are only addressing this statute with how the freestanding right must be applied. And I will point your honors to a very strong analogous case from Arizona. This is Fay v. Fox. I believe it's in our papers. It's 251 Arizona 537, which dealt with a very similar body of law, also providing a right to be heard within the Declaration of Rights, also using the term implemented. It found that a particular statute was silent on whether the right to speak existed. And it read, just like we're asking this court to do, and just like the courts have the power to do under their own rules, to read the right to speak as being provided within the constitutional text, and therefore under a statute that's otherwise silent. But this statute isn't silent. This statute
What does as implemented mean? Who's doing the implementing?
The implementation would be done, if necessary, by the legislature. But it doesn't mean that the legislature must implement. It must be shaped in the implementation. But when the legislator says nothing, then the right exists as provided by the Constitution itself. But again,
What about the rulemaking authority of the court?
we would argue that the court has independent rulemaking authority and should use that rulemaking authority in order to provide the maximum, to look to the Constitution. I believe this exact term was in Fay v. Fox, to treat the Constitution as a floor, not a ceiling.
How should we address our traditional canons of statutory interpretation when we're looking at similar statutes and we observe that the legislature has in fact put an opportunity to be heard in, say, a sentencing statute, but not the vacator statute?
Well, so with regards to the sentencing statute, I mean, this doesn't get exactly to the heart of your question, I believe, but the short answer to the heart of your question would be that we should read these statutes in pari materia, so as part of a larger whole.
Well, don't we also usually apply the canons to say when the legislature is silent in one instance, but gives a right in another statute, we presume the legislature knows how to create that right when it intends to do so.
So I want to stress the cross-reference to 11403, because Mr. Lee does not believe that the statute is silent. The statute incorporates by cross-reference.
So the rule is where the cross-reference is, isn't it?
The rule is the implementing rule. So it is how the circuit court must apply the vacatur statute and how they should go about their fact-finding. And again, this is so important because there needs to be an adversarial check in order to provide a meaningful review. And if we were to go just to the facts of this case, and the facts of what happened at the court below was that we saw the complete absence of any meaningful review. And we saw that from the very outset. And I'm happy to be through those facts again, because it goes through the course of two different proceedings where just about every right that exists for a victim was deprived, including notice, attendance, including the right to be heard. I mean, let me talk for a moment about the in-camera proceeding that occurred on the 16th of September last year, because that was the only time that evidence was presented. It was the only time that the court actually reviewed the supposed Brady material on which the court ultimately ruled. The court, in order to grant a vacatur based on the Brady evidence, assuming that it even could, considering that was not the subpart that the state moved under, but if it could, it would have had to have found that the Brady material had a reasonable probability of changing the outcome. And that evidence was never described, never released, never presented to Mr. Lee. And so the fact finding that had to occur simply didn't occur. Regardless, it was at that in-camera hearing that the decision to hold this gets to the notification and attendance question that was brought up previously. The decision to hold the vacatur hearing happened in that in-camera hearing. It was scheduled for less than one business day afterwards. There is no way that Mr. Lee could have traveled across the country in that short amount of time. The only way that one could consider that notice reasonable is if Mr. Lee had already expressed his desire not to attend. But he didn't even know when that hearing was going to occur because that hearing wasn't announced to him until after the in-camera hearing on Friday the 16th. So he never received notice. He was never told. He never received notice prior to that in-camera hearing. He was never told that he could attend the vacatur hearing in person. That was never given to him. For what it's worth, he was never told the location of where the vacatur hearing would be, which is written squarely into 11-102. So all of the, 11-104. So all of these things
Mr.
were
Rubin,
forbidden.
can I interrupt for a moment? Do I understand your premise to be that a victim should be in attendance at an in-camera hearing before the court, where generally in an in-camera, there may be only one party? There's a reason for it to be in camera normally. We have a lot of in-camera hearings. You and I can both agree with that, right?
course.
And oftentimes in-camera hearings are held only with the state, because of what they're geared toward. I understand that what you're arguing is that the victim in this case had a right to be at the in-camera hearing. Is that the premise?
That, Your Honor, is the premise, but Mr. Lee is not arguing that all in-camera hearings require a victim to be present. This was an extraordinary situation, which was unlike any in-camera hearing this council has heard of before.
Well, we may disagree just because of our experiences about the extent of in-camera hearings, but so here, the premise is that he was entitled to be at the in-camera hearing and that he was entitled to challenge the state's presentation of evidence at that in-camera hearing. Is that the second premise?
We believe that in order for the court to fulfill its role of meaningfully reviewing the evidence with no adversary ever part of this motion or this hearing, that Mr. Lee, through counsel, or if this court were to order as such, a friend of the court, the state.
Yes. So the answer is
Your Honor.
yes. And then I guess the other thing that I don't understand is the concept that a circuit court judge, for meaningful deliberation or review, has to have an adversary proceeding going on before it. Because you and I both can agree that oftentimes there lack that sort of notion of adversariness. And yet the circuit court reviews the evidence and with its authority makes a decision. What is the implication of the notion of that a circuit court cannot have meaningful review without adversariness? Or is it limited to this case? And why is this case different?
So Your Honor, we would never suggest the first thing that you said. This case, I keep using the word, is extraordinary. And it's extraordinary because it's not like a joint agreement, even a plea bargain, where you have two parties who effectively agree on the disposition of a particular question. Instead, you had two parties who were aligned before the very first word on the motion was written. And because of that, the question of whether there was, let's call it adversarial evidence or an awareness of what the alternative point of view, that never entered the process and it never appeared before the judge. And so giving full discretion to the circuit court and understanding that the circuit court just wanted to get to the right answer, it was impossible in this situation to be able to really review the evidence, because everything that was before the court was framed from one side with a zealous advocacy pointed from one side.
But isn't that, the statute contemplates exactly what you've described. And so it does seem like this is a completely legitimate argument to make to legislatures to change the framework of the statute. But there's nothing in the statute that gives the victim's representative an adversarial seat at the table, is there?
Well, Your Honor, I mean, again, we believe it exists as a freestanding right. We believe it exists as a cross-reference. But more importantly, the vacatur statute was drafted with the notion of victimless crimes. It was drafted to address thousands of inappropriate marijuana convictions, to go after the Baltimore gun trace task force. And in none of those instances was there even a question about the interests of justice. It was definitely in the interests of justice. It was highly unusual for the vacatur statute to be used in the situation it was used here to effectively reverse 20 years of law of the case and appellate court rulings.
The statute is drafted broadly enough to cover this situation. And in fact, the statute contemplates that there will be some victims. I mean, there are victims' rights written into the statute. So back to Justice Booth's question, why isn't this just a matter of asking the General Assembly to explicitly add more rights into it for a victim?
If one looks to the Judiciary Committee testimony and listens to all of the witnesses who understood that the right to be heard was already there within the statute, and considering the court's right to issue rules and implementing a statute, we believe that everything that's necessary to do that is here now.
Mr. Rubin, you are now.
Does the court have any more questions? Thank you, Your Honors.
Simonson?
May it please the court, Derek Simonson on behalf of the state. This case is not a zero-sum game. Mr. Lee's rights as a victim's representative in this case could have been honored without preventing the state from using its authority to seek to vacate petitioner's convictions in this case. From the outset, I want to make one point clear. The state's position is that regardless of whether or not Mr. Lee had the right to be heard, his rights as a victim's representative were violated by the lack of notice and the inability to attend in person in this case.
The counsel, is it really the lack of notice or the quality of the notice that was afforded?
Correct, Your Honor. It's really the quality of the notice that's at issue here. And it's that notice that directly relates to the inability to attend in person as well. Now, that's not to say the state's argument is not that Mr. Lee did not have the right to speak. He certainly did for the reasons that have been discussed previously. However, I do want to emphasize this right to attend in person because that hasn't really been addressed much so far in these arguments. That right to attend in person certainly would have been baked into the statute when it first was adopted. The thing that occurred in between, obviously, is the COVID pandemic and the increase in electronic proceedings that have occurred within courts. Now, the ability of having courts hold electronic proceedings is not meant to supersede in-person proceedings. Rather, it's to increase access to the courts, not to limit them. And so there may be instances where electronic proceedings are occurring because of health concerns, because of a different pandemic that might occur, or for practical reasons, that there may be courtroom efficiency types of reasons that would cause a court to have a proceeding that is virtual. None of those are on the record in this particular case. That when we're actually looking at why Mr. Lee was attending in person, he certainly didn't express an interest to attend virtually at the outset. It appears from the record, as best as we can tell, the state's attorney's office assumed that's what he would do. He was not actually told of an option one way or the other. By the time he was informed of the hearing, he was told he had received permission from the circuit court to attend virtually. That certainly would signal to any layperson that that is the only means of attending at that point in time, that there is not an in-person option. That even though there certainly would have been a courtroom assigned to it, he's not told where that courtroom is, what building this is occurring in, or any other information about the location besides the virtual option.
So I'll ask you the same question about the words if practicable.
Certainly, Your Honor.
If practicable can also affect the quality of, because you're talking about the quality of notice.
Certainly.
Correct? So what is, if practicable, how does that factor in here? Would it have been, and I'll ask you the same question, is the if practicable, does that go to whether he should have been advised in the hearing set according to his needs, meaning should he have been considered?
Yes, Your Honor.
Is that the state's position that the hearing should have been set in consideration of the victim's ability to attend in person?
I would say yes, Your Honor, generally, with a bit of a caveat. Now, I will say in this.
Because if practical has been in the statute
Exactly.
since the 80s, and it dealt with, that was put in by the State's Attorneys Association to avoid a situation where it would impair the ability to continue by trying to find victims and try to determine the role because they weren't given party stamps. So
Certainly, Your Honor.
this is different than if practicable in the 80s.
It is, Your Honor, and I think the difference here is that there's nothing on the record to indicate that there was a practical impediment to Mr. Lee attending in person, and I'll give an outlier type of.
No, but that's a different issue. We know you're measuring it in hindsight. I'm asking, taking into consideration that everybody's seated or the parties are there and they're trying to determine when this vacator hearing should occur. I'm going from the hearing forward.
Certainly.
So is it the state's position that the victim's presence in person should have been considered, was mandated, let's put it this way, as a consideration in setting the hearing?
Yes, Your Honor, and one of the reasons why I believe that's the case here is because the prosecutor did have discussions with Mr. Lee ahead of time. Mr. Lee expressed an interest in any hearing that might occur. And so certainly with that in mind, now it would have been a different story. Let's say the victim could not be located. They had moved to an address that the state's attorney's office used all practical means it could to try to locate the victim and simply hadn't been able to. That might be a different story. What we're talking here, though, is that the state's attorney's office is on notice that Mr. Lee has an interest in this hearing. Certainly, they are also aware that he lives across the country. He's in California as well. So the question of, is Mr. Lee able to practically come here to the hearing or not? Now, if Mr. Lee had said, there's no way I could make it, I'm busy with work for the next 6 months, and I would not be able to travel to the East Coast for 6 months. I think at that point in time, certainly, a court would not be required to put everything on hold and for a victim in that type of situation. There's nothing like that on the record here, however. And I do want to emphasize that obviously we're talking about a victim's representative who lives across the country, but when we're talking about a 1 business day's notice of a hearing, I think there's many instances where there could be individuals, for instance, in Baltimore itself, that may have difficulty attending a hearing on 1 day's business notice. People may have difficulty getting off of work, arranging travel, arranging childcare, arranging elder care. There's any number of practical considerations that if a victim has expressed an interest in wanting to attend a hearing and the prosecutor is aware of that interest, certainly that should be part of the discussion of when that hearing is going to occur. Now, that doesn't mean that a court would ignore statutory deadlines or that there may be other issues that occur. And going back, I think it's the question that you had asked, Your Honor, and also Justice Braun about the practicability. I think practicability does recognize that there may be extraordinary circumstances, there may be discretionary issues where a circuit court is able to set aside what otherwise are mandated rights for victims, but the circuit court needs to be able to articulate those and put those on the record. And the hearing here certainly didn't indicate that the circuit court, that was the reason why Mr. Lee was not there in person. That's why he was attending virtually. The circuit court indicated to Mr. Lee's counsel initially that, well, he should have told them on Friday before he was even aware that there was a hearing scheduled of his interest to be there in person. By the time Mr. Lee's notified of it, he's already told that it's by Zoom. It's already been scheduled virtually prior to him actually even becoming aware of when the hearing would occur.
Are you saying that the circuit court did not exercise discretion in determining whether notice was given under the state? I missed what you just said. I didn't understand that.
Certainly, I think the point is that if the circuit court had a reason, and this goes back to actually the appellate court's holding as well, that if all the parties are attending in person and the victim wants to attend in person as well, and there's no reason for why the victim could not attend in person, then the victim should be able to attend in person. And it's that last piece that there's nothing on the record here to indicate the circuit court saying there is no reason, we simply could not accommodate Mr. Lee attending in person. I certainly understand the urgency that this type of hearing engenders, that there is an interest in getting this scheduled quickly and rapidly. The continuance that Mr. Lee was asking for, however, in this particular case was only for 1 week. And so certainly that was reasonable. There's nothing in the record even to indicate that had the circuit court addressed the issue and said, I don't believe a 1 week continuance that's too long. Could we do it on a shorter period of time? There's no discussion whatsoever along those lines. It's simply, you should have let us know sooner than you did. Letting us know the day before the hearing that you were going to attend virtually sealed that at that point in time.
Before your time runs out, I'd like to ask you about the right potentially to be heard. What's the state's view? I know from your briefing that you don't fully agree with Mr. Rubin about this, but what is the state's view of the extent of the right to be heard in a vacatur hearing?
Certainly, Aaron, I do want to clarify that as well, to not give any misimpression from our briefing. The state's position is that Mr. Lee is able to address the court, and the subject of what Mr. Lee would talk about certainly could be wide-ranging. If Mr. Lee would want to discuss what he believes are shortcomings in the motion, he certainly could do that. That doesn't mean he would be introducing evidence. That doesn't mean he would be bringing witnesses or anything along those lines. But I don't believe there's anything within the statute that would limit his ability to speak to the court solely to the impact of him on the crime, for instance. And those limitations are in other places in statutes. For instance, for victim impact evidence, there is a very narrow band of what the victim is going to be addressing. But otherwise, if the victim is able to address the court, the victim should be able to speak on any of those issues.
And where does the state find the existence of the right to be heard? We've heard two very different views so far, but where does the state locate the right?
Certainly, Your Honor. The state largely agrees with Mr. Lee's counsel on that position, that, again, there's a constitutional principle generally that's at play here. We have a statutory right, obviously, for victims that's located in the vacatur statute. And then you have the cross-reference, again, to the motions to sentencing motions, essentially. And the vacatur hearing is very akin to those in that sense.
Mr. Simmons, what do you make of the suggestion that the sufficiency of the trial court's articulation of what happened and the in-chambers conference was not, what do you make of the sufficiency of the trial court's articulation of what occurred in chambers?
I think, Your Honor, part of what I believe the circuit court was trying to do in that instance was to create a record of exactly what the discussions were around scheduling the hearing. I do believe there's a lot of gaps, and I think going back to Justice Pateglia's question, there's certainly a question of about to what extent the victim was considered in that process. And I believe because the victim had at that point indicated his interest in exercising his rights, that should have been considered as part of that in-camera hearing. I don't agree with Mr. Lee's counsel that Mr. Lee would have had a right to be at that hearing and participate in it. However, his views certainly should have been conveyed by the prosecutor to the court.
If with the senior justice's permission, may I follow up?
Yes.
To your last point about disagreeing with Mr. Lee's counsel about attending the in-camera hearing, that was the time and place at which the evidence supporting the actual evidence supporting the motion was presented to the court. The state's position is that notwithstanding the right to be heard, the victim doesn't have the right to actually see or be privy to the evidence supporting the motion.
I think in some ways, Your Honor, that question gets to the merits of the underlying motion itself, which in theory would be presented as part of the vacatur hearing. I think there can be valid reasons. Certainly it appears from the record here that the reason why the state wanted to have an in-camera hearing was because of the ongoing nature of some of the investigation. And so there was some evidence that the state felt that could be compromised by presenting that in the open outside of the vacatur hearing, that there was still a belief that the state could meet its burden under the statute while still withholding some information that would only be for the background of the court in deciding that motion.
I think that will have to be the last word on that one.
Thank you, Your Honor.
Thank you. So is that on the city?
Your Honors, speaking specifically to Justice Battaglia's question regarding practicability, Your Honor, the rule and the statute and the victim's rights rule, the right of victim's notice is triggered by a hearing being scheduled. And perhaps it would be a better practice, and perhaps often is the case, that consultation with a victim's representative, or if they have counsel, may be taken into account in scheduling a hearing, but that is not what is actually required under the rule or the statute, Your Honor. And I also think in assessing the practicability factors, one factor is the fact that the state was making this sort of extraordinary confession that Mr. Syed had been wrongfully incarcerated for 23 and a half years.
Let me ask you about that. Where in the petition does it say that he was, I mean, it sounds like you're saying that the state took the position that he was actually innocent. But as I understand it, the petition specifically says the state is not taking that position.
No, Your Honor, at the time of the vacatur hearing, the state did not take the position that Mr. Syed was actually innocent, nor did it need to move under the vacatur statute. It took the position that new information had come to the state's attention that called into question the integrity of the verdict, which was, or the integrity of the conviction, which was what was required. There were, and that sort of come up in Mr. Lee's counsel's sort of attack on the process, where there are two decision points here. The state moved to vacate the conviction because of not only what the state viewed as a Brady violation, but other factors as well that are laid out in the petition. And then additional information that was developed, the state used that information to determine if it would dismiss the case or if it would pick a new trial date and re-prosecute Mr. Syed.
But why an in-camera hearing to present evidence of a Brady violation? Why does that have to be shielded from view of the victim and the public, and frankly, this court?
Your Honor, the record, I think, is explicit that the state's reasons for doing so was that it was an ongoing investigation. And even in the victim statute itself, there is a caveat that says certain information may not be, in the instance where it may compromise an ongoing investigation or in a circumstance in which the victim itself might actually be a suspect, that it's appropriate not to disclose information to the victim.
I guess what's troubling me about that is the concept of a Brady violation is that this information that should have been turned over to the defense so that the defense can use at the trial was withheld. So if this very information had been produced to the defense in time for defense counsel to use it at trial, that evidence would have been aired out publicly. So how does that square with holding an in-camera hearing on the basis of a Brady violation, which the premise is that it's going to be aired out in public so that another suspect can be considered by the jury?
Certainly, Your Honor. Well, I believe that issue is not before this court. However, and of course, I'm not the state, However, all we have is sort of the state's representation, and that in their view and in their prosecutorial role, they view that it was not appropriate to disclose this information, given that it contained information about a suspect. But the state did in great detail describe what they perceived as a Brady violation at the hearing, and in its affidavit that was submitted to the court. They simply didn't provide the document itself and go into full detail about the document. But I believe that I'm in a bit of a disadvantage because I'm not the state and can only sort of represent what's in the record, that in the state's view, that it would compromise their investigation.
One of the concerns that is before the court about the in-camera hearing is that it seemed to exceed a mere presentation of this Brady evidence. That there's circumstantial evidence that decisions were made, such as release on electronic monitoring. In reviewing the state's motion and the response to it, there's absolutely no request for electronic monitoring. And nothing is discussed on the record at the hearing, but yet there's placement on electronic monitoring. There seems to be a predetermined understanding of what the Brady violation would constitute. The judge didn't describe that initially for decision. She simply announced it's been found. There seemed to be a predetermined knowledge between the parties and the court that there would be a press conference after the hearing. And there seemed to be predetermined information that the defendant would need and street clothes would be provided, that the motion would be granted. So the concern is that this was a hearing that was more than just a disclosure of Brady material, that it was an in-camera hearing where significant decisions were made that should have been made on the record in the hearing, and that Mr. Lee, the victim's representative, didn't have an opportunity to participate meaningfully because decisions were made in camera. Can you address those concerns?
Your Honor, I think first it's important to note that the appellate court found that Mr. Lee did not have a right to attend. And I understand that this doesn't go directly to Your Honor's point, but I think it's important to note that Mr. Lee, the court held that Mr. Lee didn't have a right to attend the scheduling conference, the in-camera hearing, and neither.
Everyone would agree with that in principle, that there wouldn't be a right to attend a routine scheduling conference. But given that the facts far exceed this, can you get to that?
Your Honor, I may. I will, Your Honor. The second part that I just wanted to say is neither the state nor Mr. Lee sought cross-cert on that issue, where the court held that he didn't need to be, that he should not be a part of it. And I also think that the state moved in the vacature proceeding for that should the court vacate the proceeding, that it consented to Mr. Syed being released and on some sort of monitoring. I believe that is part of what was in the motion itself. And so that was before the court. In this, well, I am out of time if the court doesn't.
Any other questions from the court?
Well, I would love to hear the rest of the answer to your question.
Please consider.
Your Honors, it's our position that this case is moot because of the lawfully entered null process. So to the extent that this court is troubled by the manner in which this vacature occurred, I certainly don't have to tell you all that this court may craft an advisory opinion that addresses those things. But there is no criminal case for which this court can remand, Your Honors. If the court has no additional questions.
Seeing none, thank you.
Thank you.
Mr. Rubin, you will follow.
Your Honors, as to the in-camera hearing specifically, we've now gone over this quite a bit, I feel. The Brady violation evidence was not new by any means. It pertained to facts that had occurred 20 years previously, and to the extent it was an ongoing investigation, certainly there could have been some finding by the court to close a proceeding with regards to that evidence, but there was not a court reporter there. There was no documentation made of what was discussed, and the judge stated in both her oral ruling and written ruling that the decision was based on in-camera evidence. The right to attend a proceeding and the right to be heard at a proceeding is provided by 11102 and 11104. 11503 defines a post-conviction proceeding as any.
If at the hearing in open court, the circuit court had essentially replicated what happened in the in-camera hearing, and assuming that there was sufficient attendance and all that, and Mr. Lee was able to hear all that, if all that had been revisited in the open court hearing, would that obviate the concern about the absence at the in-camera hearing?
Your Honor, going back to the very first thing counsel said here, this is not about the underlying innocence or guilt. And ultimately, if the fact-finding process plays out and there is good merits to support the vacatur motion, Mr. Lee would absolutely support that, but that requires the full fact-finding process to play out, including the right to be heard, including the right to see the evidence. So that absolutely would help assuage this concern. But it requires a meaningful check and a meaningful adversarial process. And if I might, I would like to just go back to the right to be heard briefly. One of the key distinctions that the appellate court made, which Mr. Lee disagrees with, is the distinction between a vacatur hearing and a sentencing, and why the right to be heard is okay at a sentencing and not at a vacatur hearing. And just briefly, I will note, query why the appellate court noted how similar they were in regards to a vacatur hearing being like the ultimate sentencing. That said, the appellate court said that it was a discretionary ruling at a sentencing and a non-discretionary ruling at a vacatur. In order to grant a vacatur under 8-301.1 requires being provided in the interest of justice and fairness. That term has been analyzed in multiple analogous bodies of law to be a discretionary decision and a discretionary state of appellate review requiring a consideration of broad categories of evidence for which the court may rule. And just like a sentencing may consider multiple types of evidence, the vacatur process requires considering a wide range of reasons in order to grant that it's in the interest of justice. And I'll note that the only time in the uncited case, Walker v. State, that the vacatur statute has actually been considered before, it was done, it was reviewed for abuse of discretion. At a sentencing hearing under cases like Lopez, in fact, the language from Lopez is very telling. The language from Lopez says, judges have the discretion to admit any form of victim impact evidence beyond statements and testimony at sentencing hearings. And we believe that for the exact same reasons that it's necessary at a sentencing hearing, it's necessary to vacatur hearing to provide that meaningful check. It's worth noting.
In the sentencing hearing, the one big difference is that the statute gives an express right to be heard.
11-403 does. 11-403 is cross-referenced in the vacatur statute. And
the rule, not the statute.
I'm so sorry. And the same impulse applies because it's a discretionary ruling. If I just may, Article 47A, in the interests, it's provided for the dignity and respect of the victim. The dignity and respect of the victim is essential within what we hear today. Thank you, Your Honor.
Thank you, Mr. Rubin. Are there any other questions? Hearing none, the matter is now concluded. Case number 7 is submitted. The court will adjourn Friday, November 3rd at 10 a.m. Thank you, everyone. All rise.
You're still gonna do that. Sorry.